Welcome everybody to this month's industry update. I'm Jill Cox with Chicago Title. Before I introduce our guest today, I just want to mention that if you find value in these industry updates, the biggest way that you can support me or your Chicago Title sales rep who invited you to attend this is through placing a title order with Chicago Title. That's how we make our living. With that, I'm excited to introduce our guest speaker today. Miro, this is your first time on one of our industry updates, so we're thrilled to have you. Miro, and I don't want to butcher your last name. Is it Kovacevic? Did I get it?
Kovacevic.
Oh, not
Kovacevic,
even
yes.
close. I should have asked beforehand. I took a chance. Miro is with Goodspeed Merrill and is a real estate litigator. So he's got some fun war stories that he's going to share today and talk to us about how to stay out of hot water as real estate brokers. So with that,
Yeah,
I'll turn it.
I would
Yeah,
just
go ahead,
say that
Damian.
I've known Miro for quite some time, guys, and he is a damn good litigator. He's tough. I like to say he's a hammer, and he thinks everybody is a nail. So don't be a nail, because he will flatten you. I mean, he is, but he's a good lawyer, and he's going to give you guys some good information and things to kind of be aware of here in our industry. So, Miro, with that, I'll let you hammer away.
Well, first off, thank you guys very much for having me. I really appreciate the opportunity to speak to y'all. I gave some thought to this over the past, whatever it was, a couple of days or a week or so, and I boiled this down to like 3 or 4 areas that I think these are the areas that I'm seeing a lot of. And of course, they involve brokers at many different levels. And I think it'd just be worthwhile to go through some of these and have a discussion with you guys about this. The first one that is really in the past, I'd say 5 to 7 years, is really increased amongst real estate litigators, and I call them development disputes. And it's kind of a broad category, but it falls into 2 or boils down into 2 buckets, really. It's you have situations where a developer has refused to hand over control, and then you have issues with the development from a title standpoint. And I just want to address those 2, just explain what those are briefly, and then give you guys some ideas on how I think brokers can help their clients stay out of these situations. Because in all honesty, we all know if we keep our clients out of bad situations, we keep ourselves out of bad situations. The declarant control situation is a developer is entitled to retain declarant control, which is the right to board members from an HOA during the development period of a development. That by statute ends relatively, it just depends. It ends either when 75% of the units are sold, 2 years after the last time the declarant sold the unit, or 2 years after the declarant last exercised some, a few different kinds of development rights. I mean, it's the earliest one of those. Now, having that kind of control is obviously very important for the developer, because they need to have control over the HOA finances, manage the operations, architectural control, those types of things. So it makes a lot of sense to have those. But what I run into when I get a call, it usually is dealing with the scenario where a declarant has retained control for 5, 10, 15, and I've seen as much as 25 years after declarant control had ended. Now,
Wow.
it's insane. And does it always mean a bad thing? No, but usually when I'm getting a call, someone's upset about something, so it does relate to something bad. And the big red flag is, why does the declarant want to retain control? Of course, I deal, as Damian knows, because I had to deal with him before, I deal in worst case scenarios. And so you wonder why that's happening and why they're trying to retain control inappropriately in violation of statute. A lot of times what you see is that construction got delayed for whatever reason, financing issues, permitting issues, whatever it may be, and they want to squeeze the equity out of there, and they want to keep the HOA board on their side so they can do that. Other times I've seen even worse conduct where the developer has created a bunch of units, but for whatever reason, they're just not trading as fast as they want, but they don't want to pay assessments on those units while they hold them, and they've already brought them into the community. And so that's another reason why they do that, because they like, if they're handpicked board is looking at it, they may not care so much or realize that that's a problem. Another thing that I've seen quite a bit, and this is, I'd say in the past 5 years, is even a bigger thing. For whatever reason, the developer wants to utilize HOA property for some personal benefit, basically retaining control over common elements while they finish their development. And so when these things happen, when you look at a situation where a developer is still in control when they clearly should not be, you have to look into that and wonder why is that happening. Now, what's the problem with all these things? Well, what happens is at some point the developer does hand over control. And as part of that, they have to, submit audited financials, blah, 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 blah. If they do that, that's a separate issue or not. But what happens is by and large, the result is that you have an undercapitalized HOA. And what that means is I get the call, now I have to go after the developer because something is wrong. And we should have $500,000, $5 million, whatever, it depends on the development. We should have a lot more money in the coffers, and we don't. And it's because of some inappropriate conduct, whether or not it's intentional is a different situation, but it doesn't matter. There's certain statutory requirements of that. The other development dispute that arises quite a bit.
Can we stop, Miro, and talk about that a little bit further? I'm just curious as to what do you see for like a broker, because obviously this is newer developments or things that you're seeing this in. Obviously, if it's 20 years past, I guess it's not a newer development. But how does a broker advise their client to find out if that control is shifted or if there's going to be an issue? Do you have any suggestions on how to manage that, or is it just something that they really need to just go interview the board and find out, or go to the HOA and, well, no, seriously, I mean, go find out if the transition has occurred, or what do you suggest?
Well, a lot of the times, the fastest way to find that out is by reviewing the title commitment. Now, obviously, if you're looking at a situation of has the developer sold 75% of the units, it's going to be tough to figure that out just from the title commitment. But by and large, if you're looking at my personal experience is if you're looking at a development that hasn't been completed for 8 to 10 years, you got to start raising questions. You got to start looking at the finances. You got to make sure that you're getting all the CIC documents. I mean, the biggest red flag to me when I start getting the documents in these kinds of disputes, the broker and the buyer will hand over the CIC documents that they got. All they got were the bylaws and rules and regulations in the declaration. There's been no minutes for 20 years or 10 years or 5 years, whatever it is. That to me, when there's no minutes, that's a big thing. And so it's identifying how long has construction been going, trying to identify if there's other components that haven't been developed. You may need a lawyer for that. I'm not going to hide that fact. Yeah, you may need a lawyer to look into that.
No, I think that's an important fact, is that if you see some of these red flags, they may want to advise their clients. You may want a lawyer to review some of this to make sure you're not ending up with a problem or inheriting a problem from the previous seller or even from the developer.
Yeah, and the title commitment is, and I'm going to use this word quite a bit because there's like 3 or 4 sets of documents you can get in all these transactions that are treasure troves. I think the title commitment is a fabulous piece of information for any buyer. Now, the average buyer doesn't know what in God's name that is. And brokers obviously have to toe a line between giving legal advice and the like. But that is something getting a lawyer involved is really helpful. I think number one, though, before I even start investigating in the title commitment, is how capitalized is this HOA? Even if it's a 50-unit condominium, for example, and they have $100,000 and it's a brand new development, that's a red flag to me. I mean, if you look at any of these the maintenance reports that they can get, it tells them how to maintain and repair the development over 30 years. They're supposed to have millions of dollars in there so that they can fund it throughout. So that's the first thing, is just trying to get a grasp of what are the finances. If they seem low, why are they low? That type of thing.
And so me being the representative of brokers would be sending emails to their clients saying, guys, make sure that you properly investigate the HOA documents and the title commitment. And if you have any questions, you may want to retain a lawyer to make sure that you know what you're getting into. But given that advice up front, particularly if they see some kind of red flag with it not being completed.
Yeah. Well, and you're going to hear this a couple times today. The biggest thing is making sure you actually get all the CIC documents. Because I mean, every time I get them, there's always half of them are missing, right? And important ones like the minutes are critical for notice and the like. So that I agree with you 100%.
Yeah.
For once.
I didn't mean to interrupt you, and I didn't
No,
expect you to agree
no.
with me, but there you go. Good thing this is recorded. Okay.
Yeah. Now you have proof. Another issue, and it's not related, but it happens a lot of times as well in situations where developers may be holding on to control for too long, is the actual creation or development of these communities. And what a classic example, what I'm talking about, it's really a title issue, is let's say a developer created a 3-building, 20 units per building condominium, properly reserves development rights to create another building. Okay, there's a whole process by which that developer has to exercise the development right to bring in that property and to develop it and bring it in as part of the community. And if the developer decides from a financial standpoint that the economics are right and they want to do that, great. But they have to do it right. And what happens, and Damian is as a fellow lawyer, I mean, there's a whole progeny of cases from 2015 to even they're coming out today still, where this wasn't done right. And I think what's important to emphasize are the ramifications, because you have the situation that I just talked about. You brought in 50 units, and for 10 years, they're paying assessments. Some dispute arises, and all of a sudden you realize that building is not actually part of the community. And so what do you do? I mean, it's an absolute mess. You could have litigation for years. And when I say years, I'm not talking 2 or 3. You can have 5 or 6. And this goes back to, this is actually tends to be a little more straightforward to identify just from the title commitment. Now, how often does this happen? I don't know. What I can say from my personal experience is it's significantly higher than you would think. I bet you when I get a lot of these in and there's some issue with the developer or an owner thinks that their unit may not be whatever it may be, you'd be surprised how often people make mistakes in trying to bring in these properties. And so a review of the title commitment at the beginning with an attorney is your best chance of preventing that situation. And once again, I go back to what these 2 types of disputes is, you're really trying to avoid a major headache, because as I was referencing earlier, those lawsuits that turn into decisions at the Court of Appeals. I mean, people's properties were likely bound in litigation. They were unable to trade them for years, unless they did it at a huge loss, right? So it's one of those things that you want to try to avoid for your clients. So, looking at that, I'm not going to hide the fact, it's the lawyers can help you with this, but I'm not saying that out of personal interest. A lot of these people that come to me, and I know you guys all deal with this a lot more than me, but sometimes this is, or a lot of the times, this is the largest investment of their life. And you're looking at a few hours of work from a lawyer to just give them a thumbs up that everything's good. And that, they're not going to be stuck with this unit for a very ungodly time, and then it may not be worth, 50% of what they paid for, or whatever it may be. So,
well, Miro, I'll be a little stronger on it if you don't mind, just because I think you make a good point in that I think sometimes brokers, and I saw a question actually already pop up on this about what questions should we be asking because the client's not going to hire a lawyer or whatever. And the reality is this, guys, is that you are real estate brokers. And Miro's going to cringe when I say this, while you have a license to practice law in a limited capacity, it is limited. And part of that limitation is you're not supposed to review title documents. You really shouldn't be reviewing HOA documents. Those are things that really are reserved for a lawyer to do. And your job as a real estate broker is kind of to impress upon them, as Miro just said, hey guys, this is the biggest investment of your life. We have some red flags here, about the develop's not done, or, this was done after the fact, and there might be issues of whether or not it was put into the development or not. Maybe you want to have a lawyer review this so you're not inheriting a problem, because it's better for them to spend I don't know what Miro's billing rate is, but I'm sure it's outrageous. And so but it might be better to spend 5,000 with Miro, and I don't know if that's the price. I'm just making up numbers, guys. But um, and and have it lost and not buy a bigger problem where it's going to cost you tens of thousands of dollars. I just that's and it's up to the client to decide. And if they really don't want to hire a lawyer because they want to save two, three, four, $5,000, then that is their decision. But from your perspective, you want to give them good advice that this might be a good approach, particularly if there's these red flags. And Miro talked about some of those with the previous one. So
All right. Well, and if it's okay, I'd like to pivot to something where I think that the brokers can play a lot larger role in helping protect and investigating situations as they aid their clients. And a lot of this is from the buy side, but in this situation, I think both sides have a lot of obligations, in my opinion. I've seen a lot of brokers get involved in these disputes because they may or may not have satisfied their obligations. And those are what I describe as failure to disclose disputes. So in situations where a seller needs to disclose something and they don't, as you all know, as all the brokers know, obviously there's the adverse material fact provision in the CREC documents. But there's also a common law tort claim for failure to disclose a latent defect. But the broker's obligation is really going to be on the adverse material fact, which I actually believe to be more expansive. And it always carries with it the attorney's fees provision, which is a huge factor in attorneys advising people to pursue someone for a $20,000 or $30,000 issue because they'll get reimbursed for their attorney's fees. In any event, I thought this would be an interesting one to really provide like 4 categories of disputes that I've been dealing with over the past 4 years, and then give you guys some ideas of how I think these could be prevented on this. Because these are getting more complex. It's obvious if someone's like, oh, I know that my basement wall's out of plumb. I'm just not going to disclose it. Well, that's easy, right? That's check the box. You've screwed up. Now you're going to get screwed. But one issue, and Damian and I talked about this the other day, and I think this is a really interesting one, is off-property issues, right? What has to be disclosed? So think of a single-family home, and there's something happening in the neighboring properties, doesn't have to be necessarily adjacent. What has to be disclosed? I've been involved in disputes where a purchaser buys a single family home, and a week later, a month later, whatever it may be, they learn that the government had previously approved the construction of some improvement for governmental purposes. And antenna is a really good example of that. And we're talking, think of one of those big antennas, whatever the 5G and all those things. They're enormous.
The ones they dress up as a tree, but doesn't look anything like a tree, right?
Exactly. It looks like it's a tree dressed up for Halloween. But the question at the heart of it is that something that seller has to disclose? Now, obviously they have to know about it. But if they know about it, do they have to disclose it? And admittedly, it's not a black and white answer, in my opinion. In the disputes I've dealt with, though, it seems like everybody's leaning towards you should be disclosing these types of things. And I'll tell you, the antenna one is a really good example. In informal discussion with multiple judges on the issue, they all agreed if the seller received notice from the government about that antenna, and they do, then seller needs to convey that notice to buyer. And you guys need to keep that in mind. I mean, as you all know, the ethics or the opinion by the CRC on disclosure obligations, I think I'll describe it, and Damian could disagree with me. The presumption is if there's any ambiguity on whether you disclose it, you disclose it. Because otherwise, for a broker, your commission's at stake, including other things as well. So that's one, and I've seen that happen more and more. You have issues with all the zoning and the like, but it's one of those things where you want to ask your seller, what governmental notices have you received? And ask the question of, have you gotten notice that a property next door is going to change zoning or something to that effect? And ask that question. That will be helpful in ensuring that you are doing the appropriate digging and trying to protect your client. Another issue I had, and this is dealing with the actual property. Once again, this is a single family home scenario. There are numerous builders and the like that go throughout Denver. They raise homes and then they construct a completely new spec. This is not a new thing. It's actually across the whole state. And what happens is that the selling entity will be partnered in some way with the builder. And people come in, they buy these relatively newly constructed homes or remodel. And just sort of like the antenna situation, they find out something's wrong. They see cracks in the walls. There's flooding in the basement. There's things, just symptoms of a problem start emerging. And then what happens quite often is that people go talk to their neighbors for whatever reason. And very consistently,
I always say the neighbor brings a bunk cake, Miro, but
well, they bring information, and you'd be shocked at how many times the neighbor comes over and says, "Oh yeah, there was a huge flood. There was standing water in your foundation for 6 months." Okay, that's a problem. Other ones is the house wasn't properly winterized, and it's set to, open to the elements for numerous months, and all these things happen. And it's one of this one's a little tougher for the broker to work with, but we've always taken the position for the seller that under the contract, the selling entity, that's a failure to disclose, because these guys are building professionals and that they knew that something happened that wasn't up to the workmanlike standard of a builder. And we've tried to hold them responsible for that. And because obviously from a litigator standpoint, I want to bring a claim under the contract every time because there's that attorney's fees provision. I can always go after the builder, but damages are limited. And there's no attorney's fees provision usually because there's no direct contract with the builder. But it's one of those things where when you're advising your clients, you may want to up your game on your inspector. Nothing against inspectors. I've had amazing inspectors, but I've also seen inspectors that go in, kind of do a checklist, they're done in 20 minutes and they walk out. If it's a new build, you may want to look to someone that's a little more detail oriented. Well.
Let's talk about that, Miro, because I think some people have this perception that, oh, it's a new build, so it's going to have warranty, so we don't need an inspector to go look at the new build. So can you kind of address that as to what you would say is best practice?
Well, I appreciate and understand and don't necessarily disagree that, hey, it's a new build. It's not a condominium building that's been sitting there for 50 years and we have to replace all the pipes and all the electricity and the like that. But there are issues that arise almost immediately, right? And usually what happens is if someone engages a builder to build a new home, there's always a punch list or something like that. You want to try to have a punch list. You want to have a better inspector go in. You may, honestly, I know a lot of brokers may roll their eyes at this. Go pull the permits, see if they got red tagged or anything like that with local government. Did any inspections get denied? And that takes 5 minutes, especially in the city of Denver. That is an easy investigation to look into. You want to see what insurance the builder has. Because if the builder doesn't have proper insurance, you may literally have nothing. You could buy a house that has to get torn down or has significant renovations on that. So those are some of the things that I would initially consider on how to prevent these kinds of issues, from happening in the past. But my gut tells me, especially because I've dealt, I don't know, let's say 10 or so of these in the past couple of years. If they had a good inspector at the beginning, I think that the red flag would have been raised and they would have walked. And then they wouldn't have had to deal with me for 2 years or whatever it may be. So that's something I would certainly consider. The next two, if I can pivot now, these are ones that there's so much more that I think brokers can and should do when they are helping someone buy in a condominium in particular. And there are hail issues, and I call it the bad pipe or the leaky pipe, right? So the hail issue, it's scary how consistent the fact pattern is. someone buys a condominium unit. Nothing is disclosed about hail. There's nothing in the CIC documents about hail insurance claims or anything.
Well, you don't need to worry about it. The HOA is going to take care of it. It's part of the community.
Yeah, but what happens is the hailstorm happens some year or two before the sale. And so, sometimes the seller doesn't even know about it because they bought in the interim. But then eventually what happens is
Or forgot about it, legitimately forgot about it, or weren't living there at the time, or yeah.
Or thought it got addressed because they didn't realize that sometimes it takes years to adjust an insurance claim.
Right.
But then the old story is buyer buys the unit within 3 months. Here's a $50,000 special assessment on your $350,000 condominium. And that's like, holy heck, that is obviously that's life-changing type stuff. And so that happens.
I could tell you have kids using holy heck. That's
I'm trying not to offend you, Damian. And the interesting thing about those situations on the hail issue is that it's not only purchaser pursuing seller, but a lot of times it's purchaser and seller pursuing the HOA because the HOA hasn't disclosed enough or didn't provide appropriate information for the CIC documents, whatever it may be. So now you have this, trifecta in a dispute. Obviously, it gets expensive. And I just want to describe the other scenario, the bad pipe, and then I'll give you guys some thoughts on what are the questions, what are the things that you guys can do to try to avoid these scenarios. The bad pipe is exactly what it sounds like. This is really relevant in older buildings. I'm not a builder. I would say I'm really not seeing these in buildings under 10 years old. Okay. So in condominiums above 10 years old, this is something that you should consider. But once again, the fact pattern is so similar day in and day out. Purchaser closes. A few months later, they may notice a leak. They may notice moisture in the walls. There's a backup in their unit. Of course, what do? They call for maintenance. Maintenance comes in, and the first thing he says is, "Oh, geez, it's happening again." And none of it was disclosed.
Why do they always choose the same contractor? That's what I can't figure out. Literally, they always call the same contractor.
Yeah. And so, then what happens is, I get the call. The first thing I do is I ask for records from the HOA on behalf of the owner, and prior owner had submitted, multiple, if not even 10 service requests for some faulty pipe or a leak or et cetera, and did not disclose a darn thing. But obviously what we want to do is try to avoid those scenarios and put some pressure on the seller to fix this issue instead of just ignoring it. Obviously, what you're going to do and what information is going to be asked for is going to depend on the circumstances. But older the building, we have to be a little more vigilant. Once again, you want to make sure that all CIC documents have been produced. Okay. Minutes are probably the biggest thing, but I would certainly want to make sure that you have all the insurance policies and the like, because that's an important consideration, especially if you're buying in a condominium. And I'll talk a little bit more about that in a minute. But you want to look at those minutes, and you want to make sure you have like 2 or 3 years of minutes, because if they're properly held minutes, what you're going to find is there's going to be discussion of a hail event, of an insurance claim. If there's bad pipes throughout the building, there's going to be discussion of that somewhere in the minutes. Those are big red flags, right? And you got to raise your hand and go, hold on a second, we need more information on that. And so you want to look for those for certain. But if they, another big red flag though is if they have poor minutes or minutes aren't held, just sort of like a developer, that too is a huge red flag, because that is the eyes into the operations of the HOA. Obviously, the financials are very helpful as well in these, just depending on how they're kept and how detailed they are, but they can give you a real eye into what's going on. One thing that when I get asked to help buyers come in, and brokers cringe when I do this, one of the records that an HOA is obligated to produce to an owner upon request are all communications issued to owners for the past 3 years. So you can put a stipulation in the contract that seller has to go obtain those and provide those as part of the CIC documents. The reason I find those important is that for whatever reason, boards get the gift of gab when they're writing to their owners outside of the minutes, and they say a lot more stuff in there, and it could give you more information. Okay. But you'd be surprised how many times it's like, the seller says, well, I didn't know anything about it. It's like, well, I have your email address. You were emailed this letter talking about it, but what we want is the information before we make the decision. It's not necessarily to build a case against someone. One other thing, and I know this isn't the case, and I'm sure that the average seller's property disclosure is fairly detailed. But I'd say 7 or 8 out of 10 times when I get a call about this, I get an SPD produced that is blank. And I'm like, to me, I almost want to call the broker and say, why didn't you send that back? Because usually the person's been living there for at least a year, if not 5, 10, 15 years. There's no way that something didn't go wrong in that unit. I mean, if everybody's enjoyed home ownership, we all know things break all the time. And there's no way. And I have found that when I'm representing people in the acquisition of a condo or even a single family home, and they provide nominal information on SPD, if I push it back to them, by and large, they'll respond and provide a lot more information. Go, oh, I didn't know the level of detail. Fine, great. And people that aren't trying to really actually conceal something will produce a really good SPD, right? If they write back and say, yeah, there's nothing else. I've lived here for 10 years, nothing else.
Miro, can we drill down on that one a little bit? Because you said broker pushing back. Are you talking the listing broker who represents the seller? Are you talking the buyer broker that represents the buyer? Or are you talking both?
I've never had a buyer broker that I'm working with say, no, that's an unreasonable request to ask for more information or, fill this out. There's no way that this can be blank. I've never had a situation where they push it back and say, we have zero information.
So what you're saying is that if you're the listing broker and getting a seller's property disclosure that looks blank, if nothing else to protect yourself, you might send back to the seller and say, hey, there's nothing in here. Are you sure there isn't anything that's happened in the last 10 years that you've owned this house? Because this seems unusual, and see how they respond. Obviously, they can't make them fill it out, but they should respond. On the other hand, you're representing the buyer broker who's getting it and it is not filled out, maybe responding back to the listing broker saying, hey, this is a little light. Are you sure there's not more that they should have in here? But at least you have a paper trail showing that you asked for it. I'm getting that's what you're getting at, but I don't want to put words in your mouth. But
that's exactly what I'm getting at. I think it should be done on both sides, because if it's done on both sides, these issues come to light and they're addressed. And or if it's too much for the buyer's appetite, well, then good. Then we've avoided a lawsuit down the road.
Or if they don't fill it out, it probably strengthens your case against them later when something comes up.
It might. I don't know. It depends on. I'm not gonna. I would argue that it would, but you never know. When I look at it and I get the file and the SPD is blank, I have to shake my head and I'm like, someone should have raised their hand and said, hey, this doesn't look right. And what I'm talking about is the broker should have been like, hey, to my buyer client, I'm going to go talk to the broker about this because it just seems odd that they lived in here for X number of years and this is blank. Or it's like, we replaced, the water filter in the fridge. That's all it says. There's got to be more there. There just is. No matter how good the construction.
Yeah, and what I'm hearing is code for I might sue the broker, but I won't make you say that. But that's what he's saying is, hey, somebody should raise their hand and protected my client. So be careful. This is what I'm saying. You become a nail, and you don't want to be a nail.
Well, there may be shared responsibility for the failure of that information to reach the buyer. That's what I'll say. All right. Additional provisions to consider. And I know that once again, the brokers may think you're nuts, but have the seller disclose all service to the unit during their ownership. All the invoices, they've kept them, that they have. All the warranties, that'll give you an idea what's going on in the place. Sometimes units get traded, right? And so someone sits in the unit for 6 months and they sell it for whatever reason. And they say, wow, I only own the place for 6 months. That's great. You can go to the HOA for me and get me the past 2 years of maintenance records for that unit. You can do that. And they'll give it to you. That will tell you if that had been done, and I don't know how many disputes I would never have gotten the call, right? So I think that that's really useful, and it's really not burdensome. It really isn't. You have to make a request for the CIC documents. You're asking for literally one or two more additional things. I like having the seller disclose their role of insurance claims in the unit. Once again, that's a piece of information that if some of our prior clients had, we wouldn't be here today. And then in that claim role should identify not only claims filed, but it should give some data regarding the insurance that they had and what was the result of that. So you actually get some intel. And I know that some of these things sound over the top, but as I said earlier, these people are investing their sometimes their life savings in it, and it's no different than Warren Buffett investing in a company, right? He doesn't just go, oh no, the broker said it's fine. He's doing his own due diligence. And I think that people should ask for a couple more things. And once again, I don't think that those are crazy questions, because I'll tell you the questions that get asked in discovery are a lot crazier than that. So it's a little, ounce of prevention type of situation. So
You're making me have to update my clause manual, Miro, but thanks.
What's interesting about those disputes, as I said earlier, though, is it's not only that the brokers have some responsibilities and the sellers have responsibilities, but I'm finding that HOAs have responsibility, because a seller may know that a hailstorm happened. Okay. Now, whether or not, hey, I know a hailstorm happened 2.5 years ago, whether or not that's something that needs to be disclosed depends on the facts, right? But what has happened repeatedly, and I don't know why this happens, the board won't mention it at meetings or in their minutes. And then
it's executive session. I mean, Suzanne Left's been on here a couple of times, Miro. So
I will dispute that they can talk about that and keep it in there.
I don't know if she said that, but that's my guess as to where they talk about it if it's not showing up in minutes.
Yeah, well, and the reason I raise this is that I mean, my personal view of the law is that an HOA board owes a fiduciary obligation that if they know that a causalty fits within, or arguably fits within, the terms of their insurance policy and they're going to be filing a claim, they got to disclose that. They can't hold on to that for 1.5 years and say, we've been adjusting for 1.5 years. That is, to me, it's inappropriate. The reason I raise that is you should also ask the HOA for all claims, their claim role as well. That it's not a big ask. Literally, the property manager should be able to email the insurance company. It's hit a button, send it right back. It's not a big deal. Now, whether or not you need it, I mean, obviously, if you're talking about 10,000 unit large community, okay, maybe we don't need that, right? But for the sub association, maybe at least for your building, your single family home, the amenities that you're using, like is the pool, are we going to even get to use the pool, or is it always closed, type of thing. So it's something to consider, is because that's a treasure trove of information, the filing of insurance claims, because interestingly is when you file a claim, you're advocating for yourself, right? You're not going, oh, we don't think it's a claim, but here, just take a look at this. It's, hey, hail destroyed all these buildings, come help us. And so you provide a lot of information. So if you get your hands on that, it could give you a lot of information regarding what's going on in that community. Which brings up one other dispute. And this one is nothing short of unfortunate, because there's not much that can be done from my end. There could be more done, I think, from the buy end. It's insurance. Condominiums are losing insurance like nuts. I get calls and like, hey, I want to sue my board. The insurance company has pulled the insurance, and the board has basically said they're not going to get insurance. And okay, how much money do you guys have in the coffers? We got 20 grand. Okay, how many units do you have? 200. All right. It's how are you guys going to pay for this? And why were you declined insurance? Oh, the buildings need all new pipes, but we don't want to pay for it. That's a problem, right? So when I get to my end, I'm like, usually what it sounds like is that the board is stuck between a rock and a hard place. It's, we get the insurance, but we end up forcing out half of the ownership because we've already elevated all of our assessments to pay for all of the failed maintenance over the past 20 years. Or, we just take the risk and hope that everybody's got good insurance right now until we figure something out. And that's usually what's going on. And I'm like, I don't think it's worthwhile for you to sue your HOA, because all you're going to do is make it more expensive for them to fix the area or fix the situation.
Yeah, and who gets to pay for that? You get to pay for it.
Yeah. Well, and this goes back to looking at the kind of claims the HOA is paid, what their finances look like, because the second the insurance company says we're not insuring this condominium anymore, and usually that happens, it's pretty ubiquitous, and unless you get some crazy cut rate insurance company that's really not insuring anything, all of a sudden you've lost the conventional lending market and being able to resell your unit. So the value of your units just cratered. How much depends. I'm not an appraiser, but I know it impacts your ability to sell it to the larger market. So your value is going to fall. And so if you just, imagine a buyer just bought into it, but they didn't look at the finances, they didn't look at, the maintenance records and the like, and all of a sudden, the next day they're like, well, we have no more insurance. They're stuck there for some indefinite period. I mean, it hopefully gets fixed at some point, but I don't know. The other problem, and this kind of leads into another situation, is the way that insurance companies and HOAs are trying to battle this problem. And the way the insurance companies are doing is they're putting all the risk on the HOAs. They've come up with these crazy, I call them crazy, but these insurance policies that if the HOA files a claim, they have to pay a huge deductible, like 10 times the amount that the insurance company is ever going to pay. So you're issuing special assessments for $20,000, $30,000, $50,000 on these condominium units. That's the insurance, right? So first off,
yeah, but to some degree, they don't have a choice because that's the only insurance they can get.
Yeah, 100%. So what should the owner do, and what should I think the brokers just need to remind them of these scenarios when they're procuring the insurance that they're going to get when they buy that unit. Everybody says HO6 this, HO6 that. That's great. And you want to make sure you have a loss assessment, right? That's the big one. And you want to make sure it's a decent amount and the like. The other issue that comes up, though, is, and it goes back to the leaky pipe scenario. Someone buys a condo, there's a leaky pipe, slow drip. Unfortunately, your standard property insurance policy doesn't cover that, by and large. It really only deals with emergencies, like a burst pipe, but not a slow drip. And so what happens is, your wall falls in. The HOA claims, we had no knowledge of this, so we're not negligent. You can't hold us responsible. And your own insurance company won't cover it now. So now you got to come out of pocket as a buyer for that. There are riders and different kinds of policies that your buyers can get. It's something to consider in older buildings to get insurance that can cover those types of things. Think of can't remember what they're called. It's like water ad or something like that, but it's helping them with the insurance. Now, is that technically a broker application? No, but it's something that I think brokers have the experience and hear and see about. And I think it's useful information for them to help them make sure, that they get appropriate insurance to protect their asset. So I think it's a really useful tool. I really don't have that much more at this point.
Well, we got some questions, Miro, that we'll probably
to jump into some questions. Is that okay?
Well, then I'd like to ask one first, if you don't mind, because we've like I said, we've had Suzanne Leff on here before, and she talks obviously from the defense of HOAs, and a lot of it, Miro, as I'm sure you can imagine, is think about what the board's dealing with, think about what the HOA is dealing with, and that kind of thing, which I think is valid to some degree. But I would like to have the other side of that when the HOA is acting badly. Are you successful in suing the HOAs for failing to disclose these things? Because I see that a lot where they don't show up in the minutes.
So I've never had to take it to trial, is what I'll say. There is resolution usually. Now, whether or not the HOA is forking over huge amounts of money, it's the insurance companies at this point, because the seller has a property insurance that may have covered it, so we have that policy. The new buyer's policy may even cover a portion of it, and then the HOA has their own policy on that. To answer, what I will say, in my experience, I think by and large HOAs are properly run. I only get a call in a very small percentage of HOAs, right? If they were all mismanaged, I would be inundated with 1,000 calls a day. There's so many HOAs in the state of Colorado. So it's a real small percentage. I'm not here to malign HOAs because there's, if I've never heard of a property manager, I always give them a high five. So I'm like, that means you're doing a great job because I've never even heard of you. That's good stuff. And there are really good property managers out there. There are also property managers, and we could discuss this, that built HOAs for hundreds of thousands, if not millions of dollars. And I've represented HOAs in those kinds of disputes. But I don't disagree with Suzanne that by and large, you're dealing with a volunteer board that have their own lives, their own problems, their own jobs, their own careers, whatever it may be. It's not the forefront of what they want to do. The HOAs boards, by and large, the ones that I'm dealing with, there's something else going on. Usually there is some sort of personal animus. Sometimes I've even seen, they're doing things for their own personal benefit and the like. The personal animus is huge though in HOAs for whatever reason. Board member, owner hate each other, and next thing you know, everybody's suing each other. It starts from that. I don't think I answered your full question.
No, I think you did. I think what you're saying is that when you have a bad acting HOA, you are successful at going after them when they may not disclose or do something that they're supposed to do. But you also don't want to attack Suzanne's clients about the fact that
Well,
a lot of them are well run.
Well, and the big thing is it's the litigation, because I represent, I do homeowner stuff. I do I'll do a lot of developer stuff as well. I occasionally represent HOAs if they're adverse to a property manager or vice versa. By and large, if someone calls me and says, I want $1 million for XYZ, I'm like, that's not what I'm going to do for you. What I'm going to do for you is compel appropriate conduct. It's, you have a situation where there's a failure to maintain a common element, leaky pipe, and it's continually harming a unit. Yes, can we get compensation for that? Yes, we can. But what we're really looking for is to fix the problem, because usually it's not have been happening for 2 weeks. When I get the call, it's been happening for 1.5 years, 2 years, and the owners are just at their wits' end about it, right? And that's what that's the aim of this litigation. It's not to go beat up the HOA. It's just fix the problem that is causing us to dislike each other so much.
No, that's great. That's great. Okay, Jill, go ahead and ask your questions.
Okay,
I don't
let's
want
dive
to.
in.
I don't want to trample over the top of everybody else. So.
So Diane is asking, she's always wondered, how do owners know they're getting all the money they are entitled to from the developer when the owners take over? They've been collecting dues for months and months. Did you say that when the HOA is turned over to the owners that the financials have been audited?
They're supposed to be audited now. Whether or not they are, that's depends on what you get. So yes, the declarant is supposed to give an accounting of all of the HOA's money from the inception of time to the date that they hand over control. And as part of that, those are supposed to be audited by an independent third party. So in theory, you'd be able to see what that says. A lot of times though, it gets handed over and there's no audit, and the HOA forgets to ask about it, and it's 5 years later, and then there's no audit, and then there's questions being raised about, well, hold on, that declarant owned that unit for 10 years. We have nothing in the accounting that shows they paid anything. That's where things start to unwind. But yes, there should be an audit pursuant to statute.
Okay, Colleen asks, is there a general rule for how much capital should an HOA have? So X amount of dollars per unit.
So there is, and it's a reasonable amount. Now, what's reasonable is going to depend on every HOA. So there's no standard X number of dollars or percentage of value or whatever. It really depends on, the name of these reports are escaping me for some odd reason at the moment. HOAs are supposed to get these reports that identify the amount of maintenance and repair that they're going to have over the next 30 years. And so you really want to fund towards that, but you can't switch on a light, right? Like if your reserves are, you get to one of these reports and it says you need X number of dollars and your reserves are 20% of those dollars, you're not going to go raise $5 million overnight, right? And so you got to start, the HOA should start working towards increasing assessments in order to start raising their reserves. But to answer the question, there's not a direct amount. It's just what's reasonable for that building. And that's got a number of factors that go into it.
All right. I might jump in on this next question from Bonnie, if that's okay. She's asking if there's anything we could push for that could help regulate the incomplete CIC docs that are sent out so often during a transaction. My answer to that is, a lot of brokers will request association documents to be facilitated by a title company. Most of the major title companies in Colorado work with a local provider called Association Online. I'm sure many of you have heard of Association Online. Association Online, they audit all the documents that they receive from the HOA and push back on the HOA if there's anything missing, and receive documentation from the HOA that they document their files saying the HOA said they didn't have these documents. So they're the only organization that I'm aware of that guarantees a complete package. And so I highly recommend working with them as a broker. You don't have to go through the title company. You can actually connect with them directly. They actually have an HOA expert program where you can order association documents at time of listing and have all that complete documentation put together and available to any interested buyers. So
I wonder if they'll do 2 years of HOA communications with the unit and HOA claim roll. Not that I made notes, but maybe if we should check with Terry and find out if we added that to the contract, if that would be part of their checklist.
Absolutely. Yeah, I love it.
I love it
Okay.
too.
Anything you'd add to that?
No, I love it too. That'd be great.
Okay, Mr. Alba has a question here. He says, typically these builders have their own purchase contract where the earnest money becomes non-refundable immediately or very shortly after the contract is fully executed. Does Miro have any recommendations for when the construction red flags do get raised? How does a buyer walk away and get their earnest money and deposits back?
Well, they do it. Well, I mean, it's a matter of negotiation. So if they're creating a scenario, the builder's creating a contract where your money's going hard immediately, that can be disturbing. But there's two scenarios though when you're dealing with a builder contract. One is where they've already built the home or they're just about done with it. And they're asking for $10,000. That's one thing. But you have other builder contracts where they're using your money to initiate the funding for this. So they're asking for $200,000-$300,000. I'd have to look at it, but talking about the second scenario, because that's where outside brokers are more likely going to be involved. Because if it's a spec home, builders tend to be, they're going to be one-on-one and it's going to be a custom build. I don't see brokers involved as much in those types. I mean, you're going to want to negotiate it as much as you can and try to give yourself as many outs. The biggest thing is providing that any deposits are refundable in the event that the house doesn't pass inspection. That would be kind of the watershed. Now, whether or not they're going to accept that every penny that you paid, $5,000 at the beginning and et cetera, that's a matter of negotiation, but it's your opportunity to get through inspection. Remember, go back to having your good inspector go in there and really, tear the house apart. And then you make the decision whether or not you're going to buy it. And if your inspector raises enough red flags, hopefully the contract provides that it's returned to you when you terminate.
Okay, so in years past, with new construction purchases, I have tried to include some provision for allowing the buyer to have 2 pre-closing inspections by professional inspectors over and above the builder's usual times for the buyer to participate in the inspection process with the builder's personnel. That has been variously allowed or disallowed or only accepted to be done after closing. Very frustrating.
It is, and actually, I just want to raise one other to the prior question. If there's a significant issue that's identified in the build, that's likely going to be a breach of the contract. So you could be able to sue for that and get that back down the road. So even though it's the deposits are non-refundable, if they don't deliver a workmanlike product, you're going to be able to sue them. Well, once again, I mean, it's a matter of negotiation. So trying to look at this from how, and I love that you have 2 inspections. It's phenomenal, by the way. I've never actually seen that. And done by professionals. I'm not sure you could do much more at this point. Obviously, you want to look at the insurance that they have I mean, you're not going to, you know, one of the things about new builds, and it's an annoying thing, is the punch list. Builders hate the punch list because it's, hey, there's a scuff on the other underside of this, table that extends to the wall that no one can see, but I don't like it and I want to do, extension and all this stuff. But then buyers hate it because, they're buying a new home. They've usually invested a significant amount. There's a dent in the fridge. I want a new fridge. That's fair, I think. But there's quibbling going back and forth, and builder wants to get to closing because they need the capital to start moving forward on their next venture, et cetera, et cetera. One thing to consider in addition to having these multiple outs with these inspections is considering some sort of contingency. Retaining 10% of the purchase price in escrow until all of the and that could be an exorbitant amount. So it could be like 5% or whatever. Retaining some portion of the purchase price in escrow while the punch list is addressed. And then if there's a dispute about it, it's a smaller dispute, you go to mediation, et cetera. That's one way to consider that.
Okay, Kelly has a question regarding the seller's property disclosure. Do you need to disclose small repairs, maybe a garbage disposal that broke or clogged but didn't leak anywhere, or broken sprinkler heads or garage doors spring replacement?
And that's always the question, right? I think it's what a reasonable person would consider an adverse material fact. I think a new garbage disposal, first off, you probably want to disclose that because you'd be like, hey, I just got you a new garbage disposal. Isn't this great? I would lean yes on all of those. I know it sounds annoying, but think about it this way, where my head goes when someone says a sprinkler head, how big of a deal is that? Well, if it's right by the foundation and it's been flooding for the past 3 months, it could be a huge issue. So I want you to disclose that. I'm not a water engineer and the like, so it tends to be over-inclusive. And I'll tell you, I have found personally when I bought my house, and then I find that clients are reassured when they see all this stuff in there because they don't feel like they're people, oh my God, they disclosed a sprinkler head. Like these guys have over disclosed. I feel more comfortable with it. So I think there's actually an added benefit to the deal if you over disclose. It's a pain in the butt, I know. But sometimes these sellers are making a decent buck. So it's a little homework for them. So I would advise that they include all of those things.
That makes sense. What if the HOA management company is new? Can you request this information from the previous management company? What if they will not provide any documentation?
Well, the ultimate responsible party is the HOA, right? Because the seller is the actual active party, technically asking for all these documents. HOA is obligated by statute to provide it. Now, we do run into these scenarios where the new property manager still hasn't gotten all the documents, doesn't have all the minutes and the like, especially in larger communities, because it could take a while. I tell the HOA they have to go get it from the prior party, or direct them to produce those directly to you guys. That's it. It's going to really depend on the relationship between the old property manager and the HOA, but the HOA is ultimately responsible. And if they're unable to produce those records, and that causes a deal to fail, the HOA, I get the call and I'm calling the HOA saying, why didn't you guys help me? My client close this deal. Now he's lost, a sale because of you guys. He's got carrying costs now. Are you guys going to compensate him? That type of thing. So it's really leveraging, not worrying so much about the property managers, but remembering the responsible parties, the HOA, and that the seller has a direct line to that HOA and they need to do something about it.
Imagine that. Miro's a hammer. Miro, I got to tell you, I think we're out of time, but you got a whole bunch of praise, which I hesitate to tell you in chat, that people really loved. Thank you for being on here. So
they loved you. Well, the bad news for Miro is that now he's going to be stuck doing these on the regular. So thank you, Miro, for your time today. This was great.
Thank you very much. I had a lot of fun. Appreciate your guys' time. Thank you.
Yeah, thank you, Miro. This was fantastic.
Super educational. We really appreciate it. Thanks everybody for joining, and we'll see you on next month's update.
Okay. Bye-bye.
Thank you. Bye.
Bye.